Justice, whatever decision you take. And I hope the people of Kenya are taking notice of how we are observing the constitution that they passed. And if we are disregarding this constitution, nothing will prevent us from even undermining the amendments that we are considering this afternoon. Thank you, Mr. Speaker. I beg you respectively to reconsider your decision.
Senator Cherargei.
Mr. Speaker, thank you very much. And it is sad that we have to discuss about our colleague. Mr. Speaker, as you have discretion at any point in time to reconsider and relook at your decision, because I'm aware Senator Mwaura had shown me a court order, a pre-existing court order, that was to up to 28th May, Mr. Speaker, and we would have expected that since, Mr. Speaker, you know you are our father, you are supposed to protect all of us. You are our last line of defense, and we expect when anything comes before you, especially on your colleague senator, and being our leader in this house, to take a lot of time to console, to relook. And Mr. Speaker, the advantage that was existing was you already have a court order in place. And you being a seasoned administrator, being a leader, you should have relooked at those issues that exist on the table, Mr. Speaker. Because, Mr. Speaker, if we allow this to slide, it is a threat to democracy, where when you don't agree or disagree with the opinion of your party or anybody else that has the power to remove you, they just remove you the way they wish, Mr. Speaker. And my worry goes to our colleagues who also are nominated, because they will be hanging by the thread, because they'll just be threatened. They will now need to donate their brains and their minds to somebody else, so that they don't need to make decisions that they can run afoul against the owners of party or individuals that, and I think as a threat, and it is good the fighters of second liberation and democracy like Senator James Orengo is in this house, that, Mr. Speaker, we must be careful. I beseech you and I beg of you, Senator Isaac Mwaura is one of us. Finally, Mr. Speaker, as you reconsider and look at your decision, today we are considering the constitutional amendment bill. This bill, we are told, they are supposed to address issues of marginalization, the disability, the underprivileged in the society. Mr. Speaker, sir, Senator Isaac Mwaura was nominated as a special interest group through the part of disability. If we undermine what we are supposed to be considering as part of all inclusivity, people like Isaac Mwaura was representing a special section of this society, Mr. Speaker. And therefore, if we are the ones who will now be undermining that aspect of special interest group, Mr. Speaker, then it is very unfortunate. So I think this issue, Mr. Speaker, is not only about Jubilee or majority or minority side. I think as a house, we need to stand with one of us. Just the way we stood when Senator Mithika Linturi was arrested, Senator Langat, Senator Lilegwe, and many others, the house was suspended until the matter was heard. And Mr. Speaker, we want to congratulate you then, because you always stood on our best interest as a house. So, Mr. Speaker, as our father, as a seasoned administrator, and as our leader, as our line of last defense, Mr. Speaker, I think this matter is so serious, is so very important that you need to reconsider and relook at your decision, so that, Mr. Speaker, we are aware after you have communicated somebody mischievous in the IBC can go ahead and gazette Isaac Mwaura and even gazette somebody else, because they will be using the strength of your decision. And you know this house has the powers of quasi-judicial of a high court, where you have pronounced yourself, it can be used. So, Mr. Speaker, we beseech and beg of you that this is very important. It is one of us. We look up to you to provide appropriate guidance and ensure that justice is served and it is not travesty of justice. I thank you, Mr. Speaker.
Senator Orengo.
Mr. Speaker, this matter is very unfortunate, and I think we got ourselves to blame. I want to be very forthright to the members here. I've always pleaded that this House has to comply with the court orders. And I raised this issue when we had a court order in the matter concerning the impeachment of the governor for Taita Taveta. and the House declined to obey that court order. And court orders are court orders. You cannot choose which one to obey or not. You cannot begin to now argue that this is legislative, this is what. In accordance with Article 10, a court order is a court order. And I still believe that if you want to become a nation governed by laws, then the first principle is to obey court orders. And we have not been faithful to this fundamental requirement of the law. Even this Wajir case, we have got a court order. And we said Parliament cannot be injuncted. I don't believe Parliament cannot be injuncted. Parliaments are injuncted worldwide. Even the House of Representatives, the Senate in the United States, there are a lot of court orders that are issued against parliaments. In the European court, in the Supreme Court of England, there were proceedings challenging active proceedings in the House of Commons, in the House of Lords and the House of Commons. It was presided over by a very honored Lady Chief Justice. And the orders, Parliament was injected, and the issue remained there until the appeal process was completed. So what I'm pleading with you, you cannot choose, you cannot elect and choose which orders to obey and which one not to obey. Right now, we got orders against the National Assembly, and the National Assembly is complying with those orders in the matter which is in the Court of Appeal. But we are on record here saying, you know, court orders mean nothing. I think it's a very unfortunate state of affairs. Not even during the Kanu rule would somebody say that you cannot obey court orders. That is number one. I think you've got to blame yourselves. You have said on record, in fact, Your Honor, Mr. Speaker, I was writing some article based on the two decisions which are here. And you remember Speaker Kindike made what was called a landmark ruling, where he said we cannot obey court orders. That is on record. That is on record. And I believe on questions of human rights, they are so fundamental, they are so central to our system of constitutionalism, that whenever there's an allegation, even a threat to a violation of fundamental rights, the courts can intervene. I remember in South Africa where the parliament in South Africa was trying through committee a member of the minority party, which was the Nationalist Party, the Democratic Party. And parliamentarians say, no, you can disregard court orders. We want to kick that member of parliament out. But the High Court sitting in Cape Town intervened, and Parliament was injuncted. So what I want to say, Mr. Speaker, we got to be consistent. We should settle this question, whether court orders matter or they don't. That question we have not settled. So when it pleases us, we say there's a court order. When it doesn't please us, they say court orders can go to hell. We have to be consistent. Number two, Mr. Speaker, we have now two sets of documents. A letter from the lawyer purportedly serving your office with a court order. And that letter is dated today. And there's another letter dated, I think, 10th of March. I can't read it properly. Now, all these papers should be placed before you. And I have a lot of sympathy for Senator Mwaura. I can even go and intervene for him in court, just like I intervened in the case of Senator Wetangula when he was being removed maliciously, and in fact that one he was being removed by an order of the court, and we argued and said that the court order was not good enough for his removal, and I think Senator Wetangula would confirm that. And even this time, I am ready and prepared. Last week I made a speech here and say, you got a right to protect me and I also have to protect you. So this is one of our own. We should find a better way of protecting him. Now, Mr. Speaker, the only problem that you have now is that there's a Gazette notice. And Senator Wako will tell you, in law they would say you're a functus official. The law does not allow you to recall your decision in matters like this when it is already gazetted. But I think I know how this decision can be recalled, not by you. No, because it's a functus official. Yeah, he can't. That's a fundamental principle of law. Once you have made a decision, and I think Professor Ngindiki knows that in this circumstance you're a functus official. You cannot pretend to be doing anything. You'll be in a lot of trouble, even you, if you are to revise this decision, which you have already made and is gazetted. So what I will plead with, and I had a little discussion with Senator Mwaura outside. Let me be open. And I told him exactly what should be done. But pleading here with you, I think is lamentation in this kind of circumstances. I think you better get all the papers, see when you are served. Was it before this Gazette notice? And the order of stay, what does it say? Is it staying your decision? Or what is it staying? So we need to get all these details for you to make a decision. But I plead that we should sit together, because Mwaura is one of our own, to find a way to help. But we are not going to help by pleading with you when the thing is already in the Gazette notice. Not even the President of the Republic of Kenya can do that, by the way. Once he gazettes something under an instrument of the law, it is over. I thank you, Mr. Speaker.
Senator Wetangula.
Thank you, Mr. Speaker, for this opportunity.